and I know, John, you've had some other guests talk about litigation in the employment immigration context.
Yeah.
We're getting ready to file a lawsuit over a denied EB-1A, and it's the irony is that if you actually read the regulations, the policy instructions, et cetera, there's not really a lot of guidance on what it means to be extraordinary. There's not a lot of case law or anything else. So it's not to say you should try to file weak EB-1As, but I think you've got to, I think one of the things that you have to consider as an immigration lawyer is, are you thinking about litigation as like something that happens after filing? In other words, you don't just sign up the client, prepare the application, file it, and forget about the client. There's a chance you're going to have to carry it into federal court.
Yeah, it's for employment-based immigration. This is just part of the initial consult now for L's, O's, EB-1A. It's like that's a realistic possibility that litigation is going to come, which is crazy, and it really it's so expensive and costly that it just makes it where even for the delays at the embassy to these mandamus claims, it's like immigration becomes a thing for the wealthy. That the open-endedness for all different kinds of populations it goes away because of that.
Yeah, I mean, one of the things that I try to do, that I recommend to people, is that if you get an RFE on an EB-1A, at least part of your response should look like the complaint that you're going to file in federal court. In other words, try to telegraph to the officer that you're like 3/4 of the way there, and that it's not going to take you a lot of effort to get this in front of a federal judge.
Yeah, it is embarrassing for them too, because we see these, these judges read these decisions many times and it make positive decisions, and then you can tell they're tearing them apart. Like, did you even read this thing when they send the application in? I think if regular people knew what we're sending in and the denials we get that are so ridiculous many times, I think people would be up in arms. Even people who don't think about immigration, they really, this person is obviously fully, is good for this category. What's going on that they're pushing back?
Well, one of my favorite cases out there is about oh my gosh, I've forgotten what he is, but it's somewhere in the music industry. There's a lawyer in LA, and help me out here, Arthur, if you remember what he does. He might be a DJ.
You mean
Chuck Chandler?
Yeah. He was Adele's producer.
Adele. Oh, okay. I didn't even realize that's who it was. Anyway, he won a Grammy, and Nebraska Service Center denied his EB-1A, and it's not our case, but another lawyer in Southern California sued the government in federal court. And I mean, it's embarrassing. It literally the USCIS was trying to make the argument that a Grammy is not a major award because it was a technical category or something. Is that what the?
Yeah, I think they were even say I think the Grammy was for Adele, not for him.
Oh.
And I think it was something like that. So they were saying that, I mean, the only person who could claim this major award would be Adele, and not the producer of the record, which is nonsense.
Yeah.
Well, we had a colleague in Florida. I remember it was a year ago she told me about this, but they had an Olympic gold winner, and which is written the statute for EB-1A, one-time award like the Olympics, and they still are feeder wanting criteria. And it's like, dude, the statute just says this is an Olympic winner, a gold winner. It's just open and shut, But that's the thing. We might be talking about the same case. But I remember a colleague a couple years back told me that she had sent a Grammy case and it was denied, and have to follow up on it. But it's you have to do all the extra work of filling out the criteria, even if you have a one-time award, it should be an open and shut, easy case. So a lot of times clients contact us, they want to even say, I won a gold medal, to just do a cheap case and just get it in. No, we still have to do the whole case because we don't know what we're dealing with, and it's faster than deal with litigation and have to deal with that.
Yeah. Yeah, so that case is really good. There's another recent case from the Bay Area about a startup founder. And so we just, in our RFE responses, we'll include those decisions, we'll cite to them.
Wow. Okay.
It's not like a heavy duty legal brief at that point, but at least we're putting them on notice that, the federal courts are not on the side of the USCIS, at least the way that they're writing these decisions, they're not quality at all.
It's a boilerplate language. I'm getting ISM file removal condition RFEs, where they just have a list and the things they want are all the things we submitted. And I'm like, did they at least proofread the RFE or look what we sent? Because it doesn't make any sense. What you're asking is what we gave you.